The Sir Harry Gibbs Memorial Oration is always a highlight of the Society's conferences since it was instituted after the passing of Sir Harry, our inaugural president. This will be the 13th oration, and we are delighted to have Allan Myers AC delivering this year's oration. I'm not going to introduce him. We have Justice Stewart doing that in a moment. But I did want to make one point before I hand over to Justice Stewart, and that is my role this year has been made incredibly easy by the man who came before me, Eddie Gisonda. The calibre of speakers that Eddie has been able to attract to present at conferences over the last half a decade, particularly for the Sir Harry Gibbs Memorial Oration, has taken the Society to a new level and has made my job very easy when it comes to inviting other speakers. So I just wanted to take a moment to acknowledge Eddie and to thank him for his contribution over many years to the Society. It is a very difficult job, but it has certainly borne fruit. But without any further ado, please allow me to hand over to the Honourable Justice Stewart.
Thank you, Xavier. It's a very great honour and privilege to introduce to you Mr. Allan Myers AC. It's not enough to describe him as a profoundly great jurist and an advocate who is a wonderful asset to his country. It is not enough to define him as a man of deepest learning, nor is it enough to acknowledge his extraordinary contribution as a patriot of this country to education, to art and culture. Someone said to me recently that Myers is Australia's equivalent to Lord Jonathan Sumption. No, I said in reply. England is indeed fortunate to have in Lord Sumption an equivalent to, in truth pale and diluted version of, Allan Myers. Mr. Myers is more than all of this. How can he be accurately described? The best I can do is to tell you that he is, simply and aptly, a very great force, a spectacular outburst of energy. He tells me that in the speech you are about to hear, which I emphasise I have not seen, some of that force will be unleashed on my court. In a democratic country, subject to the rule of law, that is his right. As I understand it, this force will be directed at some of the decisions of the High Court, and it will not be benign. Again, that is his right. It is of fundamental importance in our country that the work of the High Court should be subject to informed and critical analysis, as distinct from uninformed and planted slander, and where necessary, respectful condemnation on important issues. That is a right we all share, even me, although in my case it is one only silently exercised within the parameters of my own mind. Today, as a member of the High Court, I will be a witness to what Mr. Myers is going to say. That is also important. My status as a witness cannot, of course, be taken as a sign of approval or disapproval of the content of Mr. Myers' oration. I make no comment on it. But it can be seen and must be seen as a sign of a healthy democracy, where the clashes of ideas and ideals takes place without rancour, but instead with respect and courtesy to all. Ladies and gentlemen, Mr. Allan Myers.
Ladies and gentlemen, thank you, Simon, for that introduction. I'm a bit worried about the requirement of courtesy. There can be different views about that subject, I can tell you. It's an honour to deliver the Sir Harry Gibbs Memorial Oration. This is the 13th occasion on which it has been delivered, and I follow a distinguished body of 12 former orators, all lawyers, mostly judges, and quite a few Queenslanders. One thing is evident from the 12 orations, the text of which I've taken the precaution to read, is that praise for Sir Harry Gibbs, the man and the judge, is a common thread of every oration. I will not do otherwise. I knew him as a judge. I've taken from the shelves the volumes of the Commonwealth Law Reports for the period of his tenure of office as a judge and Chief Justice of the High Court of Australia, to remind myself of the reported cases in which I appeared, always, save once, as junior counsel, led by an experienced silk, before a bench on which Sir Harry Gibbs was sitting. My memory, even thus stimulated, does not yield any recollection of what Harry Gibbs said or did in any of those matters, and there were quite a number. Many of the other judges I do remember, generally not for their assistance to my client's case, it should be said. I've appeared before all Chief Justices of the High Court since, but not including, of course, Sir Owen Dixon. And Sir Harry Gibbs is the Chief Justice whose interventions in court I least remember. I infer, therefore, that in contrast to his immediate predecessor, for example, Sir Garfield, and his successors to date, that Harry Gibbs was, as Dyson Heydon described him in the inaugural memorial oration, mild-mannered, unpretentious, tactful, quiet, unflustered, and above all, unfailingly polite. That was not his only distinction as a judge. The only occasion on which I appeared without a leader before Sir Harry Gibbs was also the only occasion on which, in almost 50 years at the bar, I have been late for court and not present at the bar table when the matter, in the case in point a special leave application in which I was briefed for the respondent, was called on for hearing. I was detained by the lift in the then new High Court building in Canberra, which would not release me. When I was called upon to address the court, Sir Harry Gibbs, who was the presiding judge, cut short my attempt to explain my absence. Yes, just get on with it. Again, therefore, I agree with Dyson that Harry Gibbs was on the bench vigorous, forceful, decisive, efficient, and had authority and could be direct to the point of bluntness. In his retirement, Harry Gibbs led an active life, including as an arbitrator. I appeared before him in an arbitration in which he was presiding. Many who have long been judges, the translation to arbitrator is not straightforward, and those former judges are inclined to continue to conduct themselves as if they exercise the authority of the office of a judge. Sir Harry's manner as an arbitrator was somewhat judicial. His written judgments have a distinctive character. He wrote in clear, concise, direct, uncluttered prose. Not for him, the Bluebell Time in Kent, or 100 pages of clutter written according to a template prescribed in some course of instruction for new judges. His judgments were easy to read and his reasons were stated with as much direct simplicity as the subject allows. In this respect, he stands in contrast with much now written by judges, not accepting some friend stewards, colleagues. The only occasion on which, the qualities of personality and intellect possessed by Sir Harry Gibbs were ideal for the career he pursued. Like all of us, he possessed the vices of his virtues. I've not seen it written nor heard it said that Harry Gibbs had any of those qualities of imagination, insight or taste which are admired in mankind and make a person sought solely for the pleasure and joy of his or her company. Often it is said that the qualities that make good lawyers also ensure that they are dull. In the inaugural oration, Sir Harry Gibbs is said, like Sir Owen Dixon, to enjoy the discussion of the comedy of life. In that respect, both of those great lawyers were men of a class Horace Walpole had in mind when he said, "The world is a comedy to those who think, a tragedy to those who feel." Could it be that practice of the law causes the acquisition of a carapace of indifference to the tragedies of life? I'm inclined to think so. Harry Gibbs was born in 1917, almost a decade before my father was born, and only a decade after his mother, my grandmother, was born. Harry Gibbs grew up in country Queensland. He was born, therefore, and his character and personality formed in a world remote from today. His work as a judge of the High Court is a reminder of enduring judicial qualities not always evident in recent times. He upheld the federal character of the Constitution of the Commonwealth of Australia. He stood for the rule of law and the importance of a competent judiciary and a conscientious and honourable legal profession. I believe he was also of the view that it is not likely that a competent judiciary will be found where judges are appointed for reasons other than merit. Merit means the possession of qualities that make for excellence as a judge. They are qualities of intellect and character and a commitment to do justice according to the law. Three of the judges whose judgments I will discuss today were appointed while another orator, Senator Brandis, was Commonwealth Attorney General. I venture to doubt Senator Brandis foresaw in their legal and judicial careers before appointment to the High Court the manner of the discharge of their judicial function in one of the decisions I wish to speak about today. In that case, I believe they engaged in judicial creativity of a nature and degree not within the scope of the judicial function. In the other of the two cases, 5 judges of the High Court did not adhere, in my view, to the proper limits of judicial creativity and thereby damaged the fabric of the Australian Federation. Now, I've adhered inflexibly to a resolution made when I came to the bar that I would never read a report of a legal case out of interest or amusement, but only if briefed to do so. Thus, I have only recently, in preparation for my remarks today, read these 2 cases. The first is Love and the Commonwealth, and the second is Palmer and Western Australia. Before examining the reasons for decision in Love, may I make a few prefatory remarks. First, it is an attribute of a foreign state that it has the power to decide who is a citizen of the state and who is an alien. It follows that a sovereign state may determine whether and when an alien should be admitted to membership of the community which constitutes that state, and to expel an alien whom it chooses not to allow to remain within its sovereign territory. Sir Samuel Griffith said in Robtelmers and Brennan in 1906, much. I would add, I think without express judicial approbation, that the criteria for membership of the community should be clear, should be readily applicable in any particular case, so that it is easily known who is a member of the community and who is not. Second, it has not, so far, been contended in any proceedings before an Australian court, as far as I'm aware, that Indigenous Australians, however identified, have at any time constituted a sovereign entity separate from the Commonwealth of Australia. At least no judge has as yet asserted that in any judgment, but it must be conceded that it is very likely said at dinner parties and the like attended by judges who let it be known how virtuous and advanced are their opinions on social and political issues. The present fashion to refer to First Nations obscures important facts. If it is intended to refer to Australian Aborigines as a nation, it is false. If it means that there are many Aboriginal nations in Australia, that too conveys a wrong impression about the relations between Aboriginal people at the time of British settlement and since. At the time of the British settlement of Australia, and since, Australian Aboriginals have identified as belonging to small groups or clans generally related by family, but never as a nation. According to the Encyclopedia of Aboriginal Australia, there are about 500 different groups of Australian Aboriginals, and some larger groups may include smaller identifiable groups and clans. It is also the case, acknowledged by that same encyclopedia, that there is enormous genetic diversity within Australian Aborigines and a huge diversity of language and cultural practices. Each Aboriginal group, at the time of British settlement, had a connection to a particular locality, not the whole of the land that is now the Commonwealth of Australia, the borders of which Love concerned. That led me to this reflection. If New Zealand is to become part of Australia, a possibility contemplated under the Constitution, provided for under the Constitution, following Love, there will be an assertion that Australian Aboriginals have a long metaphysical and spiritual connection to the land of New Zealand as well. Third, it is settled that Section 51(19) of the Constitution, which empowers the Parliament of the Commonwealth to make laws with respect to naturalisation and aliens, confers power to determine who has and has not the legal status of alien and to specify the legal consequences of that status. It also confers a power to determine the conditions upon which a person may be naturalised, that is, become a citizen. Fourth, in Pochie and McPhee, Chief Justice Gibbs observed that there must be a limit to Parliament's power to determine who comes within the definition of an alien in the provision of the Constitution that I've referred to. That limit being that Parliament could not expand the power under Section 51(19) by defining as alien persons who could not possibly answer the description of alien in the ordinary understanding of that word. Subject to that obvious limit, the Parliament of the Commonwealth of Australia can establish the criteria by which a person is or is not an alien. What were the facts of Love? Daniel Alexander Love was taken into immigration detention on the 12th of August 2018, following cancellation of his visa under a provision of the Migration Act 1958. On the 10th of September following, he commenced proceedings by summons in the original jurisdiction of the High Court. On the 27th of that month, the cancellation of his visa was revoked and he was released from immigration detention. On the 23rd of November of that year, Love, by amended writ of summons, sought declarations that his detention before the purported cancellation of his visa was unlawful and was not supported by any provision of the Migration Act, and that he was neither an alien nor a person requiring naturalisation for the purposes of Section 51(19) of the Constitution. He also sought damages for false imprisonment. Brendan Craig Toms, being in circumstances similar to Love, commenced similar proceedings on the 5th of December 2018. The Toms case was determined by the High Court at the same time as Love. Each of Love and Toms was born outside Australia and each was a citizen of another country. Each lived in Australia as a visa holder for a substantial period. Neither sought to become an Australian citizen. Love identified as a descendant of the Camel-Arroy group of Indigenous Australians and was recognised as such by one elder of the group. Toms identified as a man of Gagari people and was a common law holder of native title recognised by determination of the Federal Court of Australia. Love and Toms did not challenge the validity of the provisions of the Migration Act or the Australian Citizenship Act 2007. They did not contend that the criteria stated in the Australian Citizenship Act for Australian citizenship were not within the power given by Section 51(19). The question stated for the consideration of the High Court was whether each of the plaintiffs was an alien within the meaning of Section 51(19). Thus, the case advanced by Love and Toms is that they were not aliens, notwithstanding they were not citizens under the enactments validly made by Parliament. Put another way, they contended that the Constitution recognised that there is a category of non-citizen, non-alien, of which each of them was an instance. The submissions on their behalf were put in several slightly different ways, but however understood, they amount to saying that they, by race, were Australian Aboriginals whom the Parliament could not, by valid legislation, exclude from Australia. An Australian Aboriginal is not an alien, though born elsewhere and a citizen of another foreign state. 4 members of the High Court, Justices Bell, Nettle, Gordon, Edelman, each of whom delivered a separate judgment, upheld the contentions advanced on behalf of Love and Toms. The Chief Justice and Justices Gageler and Keane dissented. Mabo number 2 was the case in which it was held that the common law, that is the non-statutory law derived from England, recognised a form of native proprietary interest in land and waters which survived the acquisition of sovereignty of the land of Australia by the British Crown. The common law did not create that native title, but recognised its continuance after British settlement of Australia. Native title could be extinguished by statute or by grant by the Crown of property interests to others, which were inconsistent with the continuance of native title. Native title allowed persons who were holders of native title rights, determined by reference to the content of traditional laws and customs. So the common law recognises a pre-existing law, including its content. The nature of the connection to land and water ascertained by reference to traditional laws and customs, which is the basis of native title, has been the subject of considerable judicial exegesis following Mabo number 2, and has been explained often by reference to spiritual and cultural connections and conceptions. Thus, native title is not created by the common law and relates to a local connection with the traditional land of a group or clan, not to the whole of Australia. Now, can I turn to the reasons of the judges forming the minority? They occupy most of, and you'll be shocked by this, 170 pages of the Commonwealth Law Reports devoted to the case. I will later refer to the views of the minority, especially to a cogent judgment of Justice Gageler. I want to quote at some length from the majority judgments to give an unmediated flavour of those opinions. Justice Bell expressed the essence of her reasoning as follows: to observe that the capacity of an alien to hold proprietary interests in land has no bearing on his or her status as an alien fails to address the core of the plaintiff's argument. Their argument does not depend on the holding of native title rights and interests. In many instances, those rights and interests have been extinguished. The plaintiff's and Victoria's argument depends upon the incongruity of the recognition by the common law of Australia of the unique connection between Aboriginal Australians and their traditional lands, with finding that an Aboriginal Australian can be described as an alien within the ordinary meaning of that word. So the question is, who is an Aboriginal Australian? What's the connection with their traditional lands? In this manner, Justice Bell accepted that Australian Aboriginals stood in a special position by reason of a unique connection with their traditional lands. In response to the connection that Love and Thomas relied upon a race-based limitation on Commonwealth power, Her Honour said, the Commonwealth's concern that to hold its legislative power does not extend to treating an Aboriginal Australian as an alien is to identify a race-based limitation on power, is overstated. It is not offensive in the context of contemporary international understanding to recognise the cultural and spiritual dimensions of the distinctive connection between Indigenous peoples and their traditional lands, and in light of that recognition to hold that the exercise of the sovereign power of this nation does not extend to the exclusion of Indigenous inhabitants from the Australian community. Remember, Love and Toms, born outside Australia, citizens of a foreign country, and are here as visa holders. In that way, Justice Bell accepted that she asserted a special status for Aboriginal Australians on account of the cultural and spiritual connection they have to their traditional lands of their group or clan. She dealt with the contention the case put by Love and Toms is to deny the attribute of every sovereign state, namely the power to decide whether an alien is admitted to its community. And she acknowledged that power is vital to the welfare, security and integrity of the nation. However, Her Honour decided that the abrogation of that power was justified in the case of Love and Toms by the bald assertion, I promise you nothing more, that the position of Aboriginal Australians is sui generis. On the question whether a person is an Aboriginal Australian, she said it's a question of fact. She had identified an Aboriginal Australian as a person of Aboriginal descent, albeit mixed, who identifies himself as such and who is recognised by the Aboriginal community as an Aboriginal. That's based on the definition proposed by Justice Dean in the Tasmanian Dams case, which did, of course, not concern Section 5119. The facts that Her Honour relied upon disclose that Love's paternal great-grandfather, Frank Wetherell, was born in Queensland. It was descended in significant part from people who inhabited Australia immediately prior to European settlement, as was his paternal great-grandmother, Maggie Alford. Love was said to identify as a descendant of the Camel Aroi tribe and is recognised as such a descendant by Janice Margaret Wetherell, an elder of that child. On the basis of that evidence, Her Honour reasoned that Love had a special spiritual and cultural connection with the land, which meant he was not an alien. Can I turn to Justice Nettle, who identified the decision for question as follows. The question remains whether Aboriginal descent, self-identification as a member of an Aboriginal community, and acceptance by such a community as one of its members constitute a relationship with the Crown and right of Australia as to put a person beyond the reach of legislative power granted by Section 5119. The reasons given by His Honour for answering the question he posed are, and I say this with respect, tortuous and obscure. He appears to have dismissed race as a consideration for determining the extent of Parliament's power under the provision. He rejected as relevant a person's experience, perception of being connected to the Australian territory, community or polity, and this is consistent with the High Court's decision in Felzon quite recently before this case, in which the court decided that Felzon, who lived in Australia for 61 years, since the age of 3, was still an alien. And I do mention that Justice Nettle hedged his statement about race with expressions such as by and large, at the level of principle, and in terms of history and precedent. A few paragraphs later, he said, different considerations apply, however, to the status of a person of Aboriginal descent who identifies as a member of an Aboriginal society and is accepted as such by the elders or other persons enjoying traditional authority among those people under laws and customs deriving from before the Crown acquired sovereignty over the territory of Australia. He said, axiomatically, a person cannot be a member of an Aboriginal society continuously united in the acknowledgement of its laws and customs unless he or she is resident in Australia. Nor can a person be a member of such an Aboriginal society unless he or she is accepted as such by other members of the society according to the traditional laws and customs of the society, deriving from before the Crown's acquisition of sovereignty over the Australian territory. Thus, for present purposes, the most significant of the traditional laws and customs of an Aboriginal society are those which allocate authority to elders and other persons to decide questions of membership, and thus, of course, decide whether a person is an alien and whether the person is entitled, notwithstanding Section 5119, to be part of the Australian community. He said, this is His Honour, that membership of Aboriginal society is necessarily inconsistent with alienage. And he referred to the Crown's unique obligation of protection to Australian Aboriginal societies. And then, and this is the only evidence that troubled His Honour to refer to, quoted a statement by Michael Dodson, a lawyer, which was as follows: "Everything about Aboriginal society is inextricably interwoven with and connected to the land. Culture is the land and spirituality of Aboriginal people. Our cultural beliefs or reasons for existence is the land. You take that away and you take away our reason for existence. Removed from our lands, we're literally removed from ourselves." His Honour remarked, by way of commentary on Mr Dodson's statement, that a connection of that kind, described by Michael Dodson, I went to school with him, he was known as Mick then, a connection of that kind runs deeper than the accident of birth in the territory or immediate parentage. The statements were apparently treated as fact. As well as quoting Michael Dodson, Justice Nettle called in aid Pope Paul III and the papal bull Sublimus Deus of 1537. The Pope asserted in that the equality of men, but not different rights according to race, which is to assert inequality. So I don't know in the end really what it was that Justice Nettle was using as the basis of his decision. It seems to have been some connection which exists ex hypothesi, not really as a matter of evidence, of persons who have certain connections with Aboriginal society and can claim some Aboriginal descent with some land. But finally, in a pithy sentence of about 100 words, His Honour concluded, "It follows from what has been said that to classify a resident non-citizen of Aboriginal descent who identifies and is accepted as a member of an Aboriginal society according to traditional laws and customs continuously observed before the Crown's acquisition of sovereignty as an alien is to treat as alien a person who is incapable of answering that description in the ordinary sense of the word, and therefore that to impose the liabilities of alienage on a member of such an Aboriginal society is beyond the legislative competence of the Parliament under Section 51 of the Constitution. As far as I can derive from almost 40 pages of complex language referring to international legal conceptions, history, social, community and spiritual beliefs, His Honour's decision boils down to a few propositions that may be stated succinctly. An Aboriginal Australian, as defined by Justice Dean in Mabo No. 2, has a connection with the land of Australia, which means that a person cannot be an alien within Section 51(19) of the Constitution and therefore cannot be excluded from Australia. It's as simple as that. It's just an assertion. The third member of the majority, Justice Gordon, appears to have taken a position yet more radical than Justice Bell and Justice Nettle. She declared at the start of her reasons for decision, "The fundamental premise which the decision in Mabo and Queensland No. 2 precedes, the deeper truth, is that the Indigenous peoples of Australia are the first people of this country, and the connection between the Indigenous people of Australia and the land and waters that now make up the territory of Australia was not severed or extinguished by European settlement." The connection referred to as spiritual is referred to by Her Honour as spiritual and metaphysical, but apparently still within the competence of a High Court judge to opine about in deciding a constitutional question. Her opinion is quite simple. The constitutional term aliens does not apply to Aboriginal Australians, the original inhabitants of the country. She asserted, presumably as a truth deeper than the law and the Constitution, failure to recognise that Aboriginal Australians retain their connection with land and waters would distort the concept of alienage by ignoring the content, nature and depth of that connection. This is, remember, an assumed connection. It would fail to recognise the first peoples of this country. It would fly in the face of decisions of this court that recognise that connection and give it legal consequences befitting its significance. And yet, that is what is sought to be done here to Mr Love and Mr Toms, two Australian Aborigines, to ignore their Aboriginality because they were born overseas, do not have Australian citizenship and owe foreign allegiance. It's not a cheap debating point to say that Her Honour has hit the nail on the head. They're exactly the reasons why Mr Love and Mr Toms are aliens and should be subject to removal from Australia according to the Migration Act. They were born overseas, don't have Australian citizenship and owe foreign allegiance. The fourth member of the majority, Justice Edelman, delivered another lengthy judgment. It's based on a textual analysis of section 5119, by which he concludes that the provision limits the power to legislate with respect to aliens. He points out that a child born in Australia of parents both of whom are only citizens of Australia could not be considered an alien within the meaning of section 5119. No one would disagree with that. A premise of the submissions of all the parties in the intervener in these special cases, consistently with the same premise in previous cases of this court, based solidly upon repeated statements of this court, is that the constitutional concept of an alien is not coterminous with any person whom the Commonwealth Parliament chooses to make statutory citizens. Complex way of saying it. That long-standing assumption is correct. Political community is not a concept which is wholly a creature of legislation. For example, a child born in Australia of two parents who have only Australian citizenship is not an alien. The metaphysical ties between that child and the Australian polity, by birth on Australian land and parentage, are such that the child is a non-alien, whether or not they are a statutory citizen. The same must be true of an Aboriginal child whose genealogy and identity includes a spiritual connection forged over tens of thousands of years between person and Australian land or Mother Nature. The connection with Australia of a child born of two Australian parents is not metaphysical. The child has a connection with an allegiance to only the place of his or her birth. It's certainly true, however, that the connection with Australia of an Aboriginal child born outside Australia is not the physical connection or allegiance present in the other case that the judge refers to. The decision of Justice Edelman distinguishes, as do the other judges forming the majority, between the rights of non-Aboriginal and Aboriginal persons, but does so on the basis of Australian Aboriginal, which is contrived and not contestable. It's based upon assumptions that all Aboriginal persons have metaphysical, sometimes called religious, connection with the land of Australia, of a kind that a person with no Aboriginal blood cannot have. I don't accept that, not having any great-grandparents who were not born in Australia or anyone after them. The fact is, in the end, that the assumptions which are said to have legal significance are in fact mere assertions of belief which cannot be examined or justified rationally. Justice Edelman says that his conclusion about a spiritual connection cannot be denied because to do so would be contrary to the essential meaning of section 5119. That's all he says. That the connection is referred to as spiritual and metaphysical. But but the children in his two scenarios are not in like case. One is born in Australia of two parents, both of whom are only Australian citizens. The other is born abroad of parents, both of whom are not Australian citizens. The only difference between them is this defined Aboriginality. The exercise of sovereignty so as to discriminate between the two cases, so as to treat as non-alien the one born in Australia of two parents who are only Australian citizens, is rational and based upon facts readily ascertainable, incontestably relevant to the exercise of sovereignty, and consistent with any sensible conception of human rights. Well, what's the significance of the decision? First, a person who's not entitled to remain in Australia under the enactments, constitutional validity of which is accepted, is nonetheless entitled to remain because he is not an alien within the meaning of section 5119. Second, the decision limits the sovereign capability of Australia to control who comes to Australia and who may remain here. As observed by Chief Justice Gleeson in a recent case, this is an element of sovereignty vital to the welfare, security and integrity of the nation, as Justice Bell acknowledged. Third, the limitation on sovereignty identified in Love is based upon race. By reason of belonging to a particular race, people are deemed to enjoy a metaphysical connection with the land which precludes alienage. Fourth, what is the criterion by which it is said the limitation on sovereignty arises? It is based upon an identification of race by reference to vague criteria which are incapable of clear and objective application. Imagine a person presenting at the immigration counter and stating that he or she, a non-citizen born abroad and a citizen of a foreign state, cannot be excluded from Australia because he or she identifies as Aboriginal and is descended in small part from Indigenous ancestors. The customs officer would look confused, but probably he'd stamp the passport when the person in front of him said, "And if you refuse me entry, I'll sue you for false imprisonment or assault or both." The test of connection with country, of belonging to the land, is a spiritual connection. A spiritual connection can never be denied or tested if asserted. The analysis based on Mabo is flawed. It concerned the recognition by the common law, that is law made by judges, of certain native title for the purposes of land claims. It has nothing to do with the usual criteria for determining whether a person is an alien as a matter of ordinary usage. I believe that the majority decision in Love is an assault on the sovereignty of Australia by the judges of the High Court of Australia. Let me turn now to Justice Gageler, in case it might be thought I've overstated things or been disrespectful. In a few pages, His Honour rejects the majority reasoning. He says he cannot be a party to implication or constitutional interpretation to create a race-based constitutional limitation on legislative power. He says that creativity of the nature and of the degree to create such a limitation is not within the scope of the acknowledged judicial function. It is supra-constitutional. In a sense, that says it all. But why have the majority engaged in such innovation? They have forgotten their judges whose function is to administer the law. They're not innovators remaking society. Their duty is to administer the law and keep the foundations of society steady. If they're unhappy with the constraints of judicial office, they should, like Doc Evatt, resign and seek election to Parliament. Palmer and Western Australia. I think this one might even be worse, actually. Section 92 of the Constitution provides trade, commerce and intercourse among the states shall be absolutely free. The head note in Palmer sets out accurately the complex provisions of the law in Western Australia dealing with emergencies. It was an act which allowed the minister to proclaim a state of emergency for 3 days, but he could extend it. Well, they extended it for 2 years, and every 3 days, and enables the minister or someone under the minister by a directive, as it's called, to determine the area of the state of emergency. And the area determined, as you might imagine, was the whole of the state of Western Australia. It must be said at the outset that the High Court has found Section 92 a difficult subject. In the end, the High Court has dealt with the difficulty by saying that the section does not mean what it says. That absolutely free means not free. In Palmer, the High Court upheld state laws which closed state borders and prohibited travel between the states. Now, if that isn't impinging upon absolutely free intercourse among states, it's hard to know what is. The 5 judges who decided Palmer delivered 4 judgments. The High Court had remitted the matter to a judge of the Federal Court to find relevant facts. The Federal Court judge concluded that COVID-19 was a risk to the health of the Western Australian population, mainly because of two factors. First, the probability of COVID-19 being imported into the population and the seriousness of the consequences if it were imported. I won't say anything about the logic of those statements. The first judgment is a joint judgment of the Chief Justice, Susan Kiefel, and Justice Patrick Dean, both early distinguished as Harry Gibbs orators. The Chief Justice and Justice Keane began by observing, you've got to listen to these words, "It is sometimes convenient to refer to Section 92 as having two limbs, the trade and commerce limb and the intercourse limb," but then went on to observe that the words trade, commerce and intercourse are a composite expression. The observation that the words are a composite expression, even if true as a matter of grammar, obscures the difference between trade and commerce and intercourse. The freedom of intercourse, whether or not bundled with other freedoms, encompasses a wide range of personal, social and public activities, especially travel, very often unconnected with trade and commerce. A proper approach to the meaning of the respective limbs would require consideration of the differences between the activities encompassed within the respective freedoms of trade and commerce and intercourse. You've got to look at them separately. There was a decision of the High Court in 1988, Whitfield, and in that case the distinction between trade and commerce and intercourse was acknowledged. But Chief Justice Kiefel and Justice Keane in Palmer said this: "Consistently with the rejection of the individual rights approach with respect to interstate trade and commerce, the court in Whitfield regarded Section 92 as affecting a limit on laws that may be made affecting those subjects. But in discussion about interstate intercourse, it took a different approach. It regarded the guarantee of freedom of interstate movement as extending to a guarantee of personal freedom to pass to and fro among the states without burden, hindrance or restriction, drawing in part on what had been said by Justice Stark in Gratwick and Johnson. It is understandable why it was thought necessary in Whitfield to make plain that Section 92 was not intended as a protection of individual interstate traders. It was concerned more generally with the effects on interstate trade and commerce. And listen to this: it's not entirely clear why it was thought necessary to retain the right of persons to pass between the states. It was not fully explained. The matter in Whitfield engaged only the trade and commerce limb. Having distinguished the intercourse limb, no further discussion about it was engaged. It was put to one side. Well, it was necessary to retain the notion of a right of person to pass between the states because the plain English meaning of an absolute freedom of intercourse among states requires exactly that. The puzzlement of their honours would have been touchingly naive in a teenager perhaps, but not in a judge of the High Court. They said that the two limbs of Section 92 should be treated the same. They then said that the bounds of absolute freedom of the section were determined by a doctrine of structured proportionality. So absolute freedom is determined by a doctrine of structured proportionality. See if you can find a hint of that anywhere in Section 92 or elsewhere in the Constitution. This is what the Chief Justice and Justice Keane said. It's not sufficient to discern why courts have favoured, I think that must be not difficult, it's not difficult to discern why courts have favoured its application, that is structured proportionality. It reflects a rational approach to the question of whether a law which burdens a right or freedom can be justified, which requires the courts to make something of a value judgment. It discourages conclusory statements, which are apt to disguise the motivation for them and instead exposes a court's reasoning. It is not obvious that the fact that the same questions are to be applied in each case, albeit in different statutory contexts, is a bad thing. It may be said that it reflects the certainty to which the law aspires. It has not been suggested in any case since McCoy that a line of arguments otherwise available as a means of justifying a law has been foreclosed. No one could doubt that proportionality is necessary to justification. The court has repeatedly said so. It cannot be suggested that structured proportionality is a perfect method. None is. But some method is necessary if lawyers and legislators are to know how the question of justification is to be approached in a given case. Structured proportionality certainly seems preferable to its main competitors. It has been said that calibrated scrutiny will ultimately end up as a rule-based approach, even though it seeks to avoid that outcome, and that the problem with tiered scrutiny is that the court's task becomes one of merely categorising the case. What has this got to do with a provision of the Constitution says that something shall be absolutely free? The elements of this structured proportionality appear to be that it is non-discriminatory, reasonably necessary, and there is no better way to achieve a reasonably necessary object. The one thing that may be said with certainty about structured proportionality is that it hands to judges the power to make decisions involving judgments about matters that are not mentioned in section 92. A further blow to the constitutional freedom so plainly granted by section 92 arises thus. This is a bit legalistic. The joint judgment accepted the submission made by Victoria that the question of constitutional validity was to be answered by reference to the authorising provisions of the Western Australian Act, rather than to any particular exercise of those statutory powers. The Chief Justice and Justice Keane said that constitutionally guaranteed freedoms operate on legislative and executive power in the sense that a question of compliance with the constitutional limitation is answered by construction of the statute. And any complaint respecting the exercise of power thereunder does not raise a constitutional question as distinct from a question of exercise of power. Now that's not a binary distinction in any sense, but they've made it such. They then said the clarification of where the constitutional question involving freedoms resides is admittedly recent. The delay in stating it may be in part explained by difficulties which attended administrative law and its remedies for some time, and which have been only resolved relatively recently. In any event, the approach taken in Wootton is that which should be followed. What this means is this. The constitutional validity of regulations made under an Act and executive behaviour generally is determined simply by whether the Act is unconstitutional. If the Act is constitutional, anything done within it must, it says, be constitutional. This new approach will encourage the formulation of acts which are framed with a high level of generality with reference to objects that apparently do not have any connection with, say, the freedom of interstate trade, or freedom of interstate movement, I perhaps should say, but can sustain regulations made thereunder or acts done in purported performance of the regulations which in fact limit interstate movement. Palmer's case is itself an example. The directions had the purpose and effect of stopping interstate movement, but because the Enabling Act did not reasonably require those restrictions, the Act could not contravene section 92, and you don't bother to look at what's done under it. I think that's wrong. Justice Gageler took a different path to reach the same conclusion as the Chief Justice and Justice Keane, and he summarised his views in a few paragraphs. At the outset, I deal with the resolution of that part of the riddle of section 92 left unresolved by Cole and Whitfield. I address what it means for intercourse among the states to be absolutely free. Now listen to this, even Justice Gageler. It means interstate intercourse must be absolutely free from discriminatory burdens of any kind, not absolutely free at all. The guarantee of the intercourse limb is of absolute freedom from laws imposing differential burdens on intercourse in comparison to intrastate intercourse, which cannot be justified as constitutionally permissible means of pursuing constitutionally permissible, non-discriminatory legislative ends. Next, I explain why compliance with the guarantee of absolute freedom of interstate trade and commerce and absolute freedom of intercourse was appropriately determined by considering whether the provisions of the Act which authorised the making of the directions of the kind impugned met the standard of reasonable necessity required to comply with both limbs of Section 92 in all their potential applications, rather than considering whether the impugned directions directly complied with that standard. Now, Justice Gageler is saying, I don't believe in structured proportionality, but I also don't believe in absolute freedom. I only believe in freedom from discrimination, which is not justifiable. And he agreed with the other two judges I've referred to in saying, you just look to see whether the Act is constitutional. You don't worry yourself about the regulations under it or the executive behaviour of public officials. Now, Justice Gageler treated absolute freedom as meaning freedom from discrimination which cannot be justified. It is evident that one may not suffer discrimination, yet in common with all others, have no freedom whatever. Thus, by this intellectual alchemy, absolute freedom comes to mean freedom from unjustified discrimination. Justice Gageler was the only member of the court who attempts to explain the court's departure from its decision in Gratwick and Johnson. It won't be much longer. It's important to consider this case. It was decided in 1945 about events that happened in 1942, height of the Second World War. The first thing to notice about Gratwick, in contrast to Palmer, is that whereas in Palmer the court spends over 95 pages emasculating a constitutional guarantee of freedom of intercourse among states, in Gratwick the High Court upholds that constitutional guarantee in clear, concise and lucid reasons in 5 separate judgments over 14 pages. In 1942, the facts are interesting. Dulcie Johnson decided to visit her fiancé, and to do that she had to travel by rail from New South Wales to Western Australia, and she did so without a permit. She had to get a permit to travel interstate during the war. She was charged under the National Security Act that she did, without a permit, travel by rail from South Australia to Western Australia. The magistrate who determined the matter dismissed the complaint on the ground that the order made under the regulations, under the Act, not the Act, the order made under the regulations under the Act was invalid because it infringed Section 92 of the Constitution. It was argued for Gratwick that the order was valid because it's authorised by the regulations and it doesn't infringe Section 92. Chief Justice Latham said this: the defence power does not exclude the application of Section 92, and that even if the regulations and the order, apart from Section 92, are completely valid, they could not be upheld because they are inconsistent with Section 92, so completely contrary to the approach taken in Palmer. The Chief Justice rejected that contention that the abrogation of freedom of intercourse could be justified by extraordinary circumstances of wartime or indeed any other emergency. He pointed out that the provisions in issue were mere prohibition of interstate intercourse. It was directed against intercourse. Justice Rich decided the order was a direct restraint on the freedom conferred by Section 92. Justice Stark decided it was immaterial that the object of the purpose of the legislation gathered from its provisions is for the public safety or defence of the Commonwealth or any other legislative purpose, if it be pointed at the right guaranteed and protected by the provisions of Section 92 of the Constitution. He referred to the right as freedom at the frontier. Justice Dixon observed there was no difficulty in the case before the court. He could not see how the order left intercourse among the states absolutely free, as Section 92 expressly commands that it should be. Justice McTiernan said that although the order was made in circumstances of grave national peril, it must give way to Section 92. COVID was different. Justice Gageler identified the circumstance that the Gratwick order considered prohibited interstate but not intrastate trade. Thus, he said, Gratwick usefully illustrates a differential burden on interstate intercourse which was not justified as constitutionally permissible non-discriminative legislative end. I didn't think that's what it did. It said Section 92 guarantees absolute freedom, but won't say any more. When Justice Gageler turned to the question whether the Western Australian legislation contravened Section 92, he said this: "The constitutional question so isolated was whether the provisions of the Act, insofar as they authorised the making of directions imposing a differential burden on interstate intercourse, was sufficiently constrained in their terms to allow a conclusion to be reached that imposition of the burden of that nature meets the requisite standard of justification across the range of potential outcomes." If you can understand that, you're a better man than me. This does not seem to me to be asking the question whether the Act imposes a burden on absolute freedom of intercourse among states. It's asking, although the Act burdens absolute freedom of intercourse, I do not think, for whatever reason, it should not be struck down as unconstitutional, or should be struck down as unconstitutional. This formulation is nothing more than an assertion of judicial power not given by the Constitution. Justice Gageler fastened on the expression reasonable necessity as a test for the requisite standard of justification, but it's nowhere found in the Constitution. Whatever the test contrived in substitution for the plain words of Section 92, the result will be that the freedom allowed by the High Court is what the judges believe is a matter of political, social or economic theory or ideology, is a reasonable restraint upon the absolute freedom guaranteed by the Constitution. In many, perhaps all cases, the judgment will be honest, well-intentioned, and maybe after a lot of soul-searching. But the fact remains that step by step the words of the Constitution are left behind, and in their stead judges have contrived to substitute a complicated confection which does not guarantee absolute or any freedom. I'll leave some of the other things that Justice Gageler said aside, I think. Perhaps going on too long. I shan't examine the other judgments in Palmer. Justice Gordon and Edelman showed no more inclination than their senior colleagues to uphold the Constitution. The exercise of power resulted in Western Australia being for 2 years closed to persons who were not within it when the impugned power was exercised by the Government of Western Australia. Other states acted in like manner. The Commonwealth of Australia was fractured. Similar powers will be exercised by states in the future. The lives, health and well-being of Australians will be harmed. What occurred was a denial of the absolute freedom granted by the Constitution. The High Court was weak, timorous, and engaged in an absurd debate about vague conceptions which are not to be found in the Constitution. The High Court failed in its fundamental duty to uphold the Constitution and protect the federation created by the Constitution. I say that respectfully. This takes me back to the inaugural oration which Dyson Heydon entitled Chief Justice Gibbs Defending the Rule of Law in a Federal System. How times change. How we need another Harry Gibbs to defend the rule of law and to uphold the federal system.
Ladies and gentlemen, it's my privilege to be asked to propose a vote of thanks to Allan Myers for his speech this morning. You've just been witnessed why Allan Myers is regarded without peer as the finest barrister and advocate in the land. He is fearless, he's intellectual, he's persuasive. Will you please join with me and thank Allan Myers for his superb speech this morning.